Today's courtroom drama centers on Herbert Kane, a man accused of assaulting a peace officer. Right away, there's confusion, frustration, and even some bizarre side stories about camping and past burglary charges. But at its core, this case is about one question. Will Kane accept a plea deal for 5 years, or risk it all on a jury trial where the punishment could be up to 20? The judge doesn't mince words, the prosecutor holds firm, and Kane, well, let's just say his answers raise eyebrows. Stick around, because this negotiation turns into a full-on clash about accountability, past mistakes, and whether justice should be bargained at all.
All right, sir, are you Herbert Kane? Is your name Herbert Kane?
Yes, ma'am.
And I'm going to take judicial notice in Mr. Kane's file. Mr. Kane was evaluated for competency to stand trial by Dr. Rapon. I've received that report dated August 13th of 2024. Dr. Rapon made the finding that Mr. Kane is currently competent to stand trial. Is there any other evidence with regard to competency, Mr. Parker?
No, Your Honor.
Ms. Malfino? Then at this time, I am going to find that Mr. Kane is competent to stand trial. Mr. Kane, you're charged by indictment.
Big moment here. The judge declares Kane competent to stand trial. This is more than a checkbox. Competency means the court believes Kane understands the charges, the risks, and can help in his own defense. If he had been found incompetent, the case could have been delayed for treatment. But now, there are no excuses. He's facing a second-degree felony, assault on a peace officer, and the stakes are serious. Question for you. Do you think competency rulings are sometimes too quick, or should the system move fast to avoid delays?
That's your question.
Sure.
I got, I guess, approached for camping out, but I wasn't there overnight. I just came back from the store.
So here's the thing. What happened surrounding this offense or what they charged you with, that's information for your lawyer. And if for some reason if you believe you're not guilty, then that's what a jury's for, and we can let your case go to a jury. That's what we're going through. So it looks like the state has made an offer if you wanted to enter a plea of guilty for a 5-year term in prison. You have every right to reject that. Let a jury decide two things. The first is to decide if you're guilty or not. And then if they find you guilty, then they can decide what your punishment is. Do you understand?
I understand, but as far as it being my first offense, I don't even get
Here's the thing. Well, here's the thing. The offer is I don't get involved in the negotiations. That's not part of my job. So the state has made their offer. If you want to take it, you can take it. If you don't, then you let a jury decide. And so I just want to make sure you understand if you go to a jury, what your options are today and what your consequences could be if you go in front of a jury.
Here's where the pressure sets in. The state offers 5 years in prison if Kane pleads guilty. Sounds harsh, but remember, a jury trial could mean anywhere from 2 to 20 years. Kane pushes back, arguing it's his first offense. But watch how the judge steps in. The offer is the offer. This is a classic courtroom standoff. Defendants wanting mercy, prosecutors sticking firm, and judges making sure the rules are crystal clear. If it were you, would you take the 5 years and lock in certainty, or roll the dice on a jury?
I've gone over it.
Okay, so it doesn't appear that it was dismissed, but I just want to make sure right now we're talking about this case. The offer is what the offer is from the district attorney's office. So you either take it or you go to jury trial.
I don't have a felony on my case as far as what she says.
Look, regardless of that, that doesn't change. Even if you had it, it doesn't change the punishment in this one. Okay, that can be figured out by your attorney very easily if you have one or not. So I just need to know if you want to take the 5 years on this case or if you want to go let a jury decide.
Might I ask her a question?
No, you cannot ask her a question.
I was trying to see if that was a felony or not.
It's a state jail felony. Burglary of a building is what.
Sorry.
Go ahead.
It was a felony conviction with county jail time, so he may misunderstand that he is already a convicted felon.
Okay, so it sounds like you got a 1244, which means you got a state jail felony conviction, but you did your time in the Jefferson County Jail. So you do have that state jail felony conviction, even though you did your time in the county jail. That's what the paperwork looks like.
So I got 1244A.
Mhm.
Okay, but from what I understood, it got dismissed.
It doesn't get, it did not get dismissed.
So 1244A is not reduced.
It's where you do your punishment in county jail. And I go over all of that with anyone who's in front of me. So I'm sure I did the same with you.
That's what I'm saying.
It's a state jail felony conviction, but we're going to stop talking about that because it doesn't matter right now.
This is where Kane's credibility takes a hit. He insists his past burglary was dismissed, but the paperwork says otherwise. It was a felony conviction. He just served time in county jail instead of state prison. That's a technicality, not an acquittal. The judge cuts through his confusion with blunt force. It doesn't matter. The charge on this case is still a second-degree felony. And this is huge because credibility matters. If you misrepresent your past to a judge, even by mistake, it weakens your entire defense strategy. So let me ask, do you think Kane genuinely misunderstood? Or was he trying to rewrite history?
So what do you want to do?
So can I ask you another question?
Sure.
So you said a quarter of it I'll be eligible for parole.
Mm-hmm.
But he said I have 100, you know what I'm saying, 100 days.
Yeah.
Back time. So
Okay.
I already did, what, like 6 months now, and I got 100 days back time.
So here's the thing. I went to law school because I'm not good at math. I have no idea. Well, do the math. I don't know. I mean, it's a quarter of 5 is
About a year and
3/4.
about a year and 3 months.
So you know.
I was trying to make sure. That's
Well,
all.
we're not here for a math test. Do you want to take the deal or do you not want to take the deal?
He asked me today, Judge, if he would get out if he took the deal. And I said you will not get out
No,
today. And
you don't get out today. You got to go get your number and do all the stuff. Mr. Parker's answered all this. I got other stuff to do. Do you want to take the deal or do you not want to take the deal? It's not going to be on the table after today. If you reject this offer today, I'll set your case for trial and this offer will be off the table. I want to make sure you understand that as well. I don't accept plea agreements once I put your case on the trial docket. So what do you want to do?
You can take it to trial.
Okay. So we'll put your case. You understand that I'm not going to take this 5-year deal and it's not going to get any better after today. You understand that, right?
How could it not get better?
Because I'm telling you it's not going to get better. I'm not going to accept a plea agreement for less than 5 years after today because I don't play with my trial docket and just put cases on it. So somebody thinks, well, if I make it last a little longer, maybe I'll get a better deal later. This is your deal today. If you don't want this deal, that's fine. It's either going to have a jury decide, which is fine, or the deal is going to be higher, not lower. Do you understand?
And here comes the hammer. The judge warns Kane that if he doesn't accept the deal today, it's gone. No second chances, no better offers, nothing lower than 5 years. That's the courtroom equivalent of a shot clock running out. The judge even says flat out, I don't play with my trial docket. This is high-stakes poker. Take the guaranteed sentence now, or gamble on a jury that could hand down double, triple, or even quadruple the time. What would you do? Lock in 5 years or risk 20?
We're doing really good with moving trials, do the best we can, but I can't tell you for sure when that would be.
Question, but one more question and I'll let you know. On that burglary on
We're not going back to that. Just let me know. We're not, no, we're not going back to a burglary. Okay. Do you want the deal on this one or do you want to go to trial?
Huh?
Do you want the deal on this one or do you want to go to trial? We're not talking about the other case again.
What's it to do?
All right. I'll hold it while y'all go. You need to do the paperwork with Mr. Parker this morning and then I'll take care of it in a few minutes.
Can I plead not guilty?
No, if you're not, no. If you plead not guilty, then you go to trial. You're either going to say you did it or you didn't do it.
Oh, I didn't do it.
If you didn't do it, then we're going to set your case for trial. So we're going to put your case on the trial docket. And so, Mr. Kane, Mr. Parker has been appointed to represent you. He's one of the attorneys who handles a lot of cases for me as a court-appointed lawyer. If with your permission, I can release him and I can appoint another attorney today who can start getting ready for trial a little quicker. Is that okay?
So here's where we land. Kane rejects the 5-year plea and pushes toward trial. The judge, clearly frustrated, releases his attorney and assigns a new one to get ready. This case perfectly shows the balance between negotiation and justice. Prosecutors offering deals, judges managing overloaded dockets, and defendants deciding whether to fight or fold. For Kane, the next chapter will be risky. Trial could mean vindication, or it could mean decades behind bars. What do you think? Was rejecting the deal smart or a disastrous gamble? Let us know in the comments. And if you found this courtroom breakdown as gripping as we did, hit like, subscribe, and stick around for more shocking cases from America's courtrooms.